Welcome back. I am attorney Nicholas Hicks. Thank you for joining us again on our YouTube channel. This is part 3 of surviving criminal charges. As a disclaimer, all the information that I'm going to share with you today is for informational purposes only. It is not designed or intended to be legal advice. You should discuss your matter with a lawyer licensed to practice in New York State to see how this information might apply to your particular circumstances. The last time that we left off, we discussed a bit about how you should dress and conduct yourself in court, assuming that you've made bail. Now, of course, there are many defendants, many people who are unable to make bail for a whole host of reasons. There's particular dangers, other than the obvious of being incarcerated, that you should be aware of with respect to your particular charges and what can happen in the future concerning the prosecution of your case. It is not uncommon for an inmate to be approached by another inmate and offered friendship by way of assistance with respect to your charges. An inmate may say, hey, let me see your paperwork. I know about these charges. I've been charged with this before. I've been in the system a long time. Come on, we'll go to the law library. I can help you, give you some assistance, help you file motions or whatever. Now, it might be the case that the offer of friendship may be legitimate, but you don't know that because you don't know this person from Adam. The danger is that most inmates are looking for a way to deal their way out of jail. I know that I've received many calls over the years from clients or would-be clients who say to me, listen, there's a guy in here with me. He admitted to me that he killed somebody, or he admitted that he committed this offense. Can you set up a meeting with me and the DA to see if maybe they would, give me some consideration on my charges if I testified against this guy? Now, this happens every day somewhere in America. And if you, especially if you're charged with a high-level offense, a violent felony or high-level drug offense, you talk to the wrong person in jail, you could see the same person taking the witness stand against you at your trial, whether it's true or not, to testify about what it is you allegedly confessed to them. The other thing that you must be careful about while you're incarcerated is other inmates getting a hold of your paperwork, even if you don't talk to other inmates, which you shouldn't, about your case. If an inmate reads your charges, they're able to pretend as if you told them about your case, as opposed to them reading your paperwork and saying you confess to doing certain things. And again, you might see this inmate testifying against you at trial. It's usually not a good bet to have your paperwork while you're incarcerated. You certainly have a right to it. Any lawyer will tell you you have a right to your entire file. But it is a danger to it, and if you do have it, you should guard it carefully, because if it falls in the wrong hands, it could come back to bite you. The other thing that you should be very careful about while you're incarcerated is that in most places, certainly here in Erie County, they tape record telephone calls that go in and out of the holding center, in and out of Alden, and what you say on that phone could hurt you. We tell clients all the time, do not discuss your case over the phone. I can't tell you how many times I've gotten a disc in the mail from the prosecutor's office with my client on the phone saying something that is against his or her own interests. Don't do it. Stay off the phone. The only time you should be on the phone is if you're asking somebody to put money in your commissary or come visit you. If you want to have a conversation with somebody about your case, which you shouldn't other than your lawyer. I even tell my clients if they call me from jail, don't discuss the case even with me, even though they aren't supposed to be able to use that information because it's privileged. You don't know what's going to happen to that information. They could still take it and expand their investigation, and I'll never know necessarily how they knew to do that, but it could be because of that conversation. So even when you call your lawyer, you should ask your lawyer simply, can you please come visit me? Talk about it with your lawyer face to face, not over the phone. You don't discuss your case over the phone while you're incarcerated. So those are the two primary pitfalls of, if you don't make bail, that you have to be aware of. Your paperwork falling in the wrong hands, discussing your case with other inmates, or talking over the phone about your case with anybody, including your lawyer. Okay? Now, let's talk a little bit about family members, because we talk a lot about people who are charged with crimes, but we don't consider often in our discussions the impact that it has on family members and loved ones and how they interact with the lawyer's office. So family members, this is important to understand. Of course you love, this person who's charged with whatever offense. You're going to have many questions and concerns. What happens sometimes is that a lawyer who's just one person will get multiple calls from different family members asking a whole host of questions about their loved one's case. You must understand that every minute that we're on the phone, answering whatever questions we can answer, which, can be very limited, we aren't using that time to actually prepare a defense for your loved one. Now, that doesn't mean you shouldn't inquire, but what it means is, and I always tell family members is, elect a spokesperson. One person in the family that the family agrees will be the person who reaches out to the lawyer with questions, as opposed to the lawyer answering the same question to 5 different family members. One person makes the call and takes the information back to the rest of the family members. That one makes it easier for the lawyer and more manageable time-wise, which benefits your loved one ultimately, and it probably reduces the risk of miscommunication. 2 or 3 people going back and 1 or 2 of them getting it wrong, and then there's mixed information throughout the family. It just becomes kind of crazy, and it doesn't do anybody any good. So again, elect a spokesperson. Now, the other thing as a family member that you have to understand is that a lawyer's duty to communicate really is only between the lawyer and the client, not anyone else. So the fact that we choose to talk to family members is really a courtesy. It's not a right. And I say that because I'm saying you should be polite when you call. I know you're under stress. I know that, this is a difficult time for you as well, but you must understand, I have no ethical obligation to talk to my client's aunt or mother or father or sister or brother or friend. Only with my client. So if I talk with you about it, it's simply out of empathy that I understand, and I'm trying to sort of ease your concerns. The other thing is that what I can discuss with you is very limited unless I have my client's permission. In most cases, I would tell my client not to even give me that permission because, again, remember that privilege we talked about. If you learn something about the case that, could be harmful, you could be forced to testify against your own family member. So sometimes it's better that you don't know certain things, even though you want to know them, for the protection of your loved one and yourself. So there's limited things that I can tell you anyway. I can tell you, when the next court date's going to be, maybe generally what's happening, but the bulk of the conversation is going to take place between myself and the client for the protection of my client. Okay. Now, let's talk a little bit about communicating with your lawyer. And we've mentioned this a little bit before, but I want to go into it a little more depth this time. Let's talk about innocence and guilt. Unless you're a lawyer or you've been trained to think this way, it's understandable that a person who's been charged with a crime is adamant about their lawyer believing in their innocence, because you feel that if I believe in your innocence, I will fight harder for you. Now that's a common human sentiment. But you must remember that as a trained professional, your guilt or lack thereof doesn't weigh in at all with respect to what my duty is to you and my responsibility as a lawyer. We take an oath that we will represent our client zealously. Zealousness comes from the root word zealot. Zealots were famous first century warriors that were so they were such fantastic warriors. They were vicious fighters. They had tremendous heart. They were such great warriors that 20 centuries later, we still refer to them by creating this word zealousness, or being, zealous advocacy. Well, that's the level of my duty to you, that I must, short of breaking the law, fight for you like I would fight for myself, or I would fight for a loved one. So that oath is not predicated on guilt or innocence. That doesn't factor into that oath at all, nor should it. Because if a defense attorney needs his or her client to be innocent to fight for them, they shouldn't be defense attorneys. This is the wrong business for them. Okay? It has nothing to do with what we do or how we think. We're trained to be advocates. We are fighters. We don't fight for what's right or what's wrong. We fight for our client. And that's what you must understand. This is our thinking, and this is how we're trained. It is more important to spend time not trying to convince your lawyer that you're innocent. It's more important that you concentrate on telling your lawyer everything, especially the embarrassing stuff. Because remember, as I said before, we can only protect you from what we know about. And it's usually the embarrassing stuff that's the most dangerous stuff that's going to hurt you. It's going to come and find you. And if we don't know about it, we're going to get surprised, but you're going to get hurt. So the bad news should be told to us faster, quicker than the things that you think make you look good. Tell us all of it, by all means. But if there's something that you know is bad or embarrassing, that's the stuff you should get out right away. It's difficult. It runs contrary to human nature, because you want to protect yourself at all times, and to kind of put your hands down and go, here's the bad stuff. You will do more good for yourself than you imagine, because that's the stuff we need to protect you from. Okay? So you can only do that if you have trust in your lawyer. And if you're going to hire a lawyer, which by all means you should, if you're charged with criminal any kind of criminal activity, you're going to have to trust your advocate. Get somebody that, good word of mouth, somebody recommended you to them, you hear good things about them, or even if they're assigned to you, even if you're a public defender, if they've earned your trust, then by all means you have to trust that they're going to do their job and they're going to do it right. That's very important for your well-being. Next time when we come back, we're going to talk about automobile stops and the significance of those things, and what can happen and how to protect yourself during an automobile stop. Thank you for joining us. This has been part 3 of Surviving Criminal Charges. If you enjoy what we're doing, please subscribe, like, and recommend to other people. Thank you for joining us. Again, Attorney Nicholas Hicks. I'll talk to you next time.